Good morning, everyone. Virgo here. It is March 5th, 2020. Happy Thursday to everyone. This is brought to you by Snoop for Truth. These are the documents that I was speaking of from the video that I put up yesterday with the verdict of Anthony Williams, so-called private attorney general's guilty conviction or guilty verdict that came in on the 2nd of March. This is going to provide you with a lot of additional information pertaining to the documents that are actually in the case, and we are going to be going over the indictment itself in addition so that everyone can take a look at what the 32 counts that he was found guilty of actually entail. What we're looking at right now is a document that was filed on the 22nd of June 2018, and this actually provides us with all of the bogus stuff that Anthony Williams was claiming to be able to provide to his unsuspecting victims. All right, so as you can see here, we've got mortgage enterprise investments, foreclosure, and deduction of interest program. And he goes on to talk about how supposedly mortgages are illegal and foreclosures are illegal. It says mortgage enterprise investments is dedicated to assist homeowners. We work only with Common Law Office of America customers to ensure an affordable monthly service payment. We have a rock-solid guarantee in that if we can't reduce your mortgage service payment to half of what your current alleged mortgage payment is, we will completely refund your $3,500 to $5,000 initial setup fee with no questions asked. All right, as you can see, I'm going through the exhibits right now. Here are some photographs of U.S. Private Attorney General Anthony Williams and his website, which was usacommonlaw.com. And the document says, see if you qualify for a mortgage payment reduction. If you qualify, Mortgage Enterprise Investments eradicates your loan and eliminates your interest rate. This is not debt consolidation, refinancing, or credit counseling. This is a unique process that our company has discovered to lawfully assist you in owning your home in the shortest amount of time. Moving on to the next exhibit, gives us some pictures of some things that were actually on the website, and him talking about foreclosure crimes. Says you as a homeowner have certain legal rights concerning your alleged mortgage. Don't let your alleged mortgage company service your loan when there is fraud involved. Let our trained representatives assist you in getting the help you deserve and the information disclosed to you regarding your mortgage. Let us give you peace of mind in knowing that your home is secure and being serviced by the right company. With your best interest in mind, don't be fooled by others claiming to reduce your mortgage and are only refinancing or modifying your loan. The funny thing about this is almost verbatim what April Lejeune actually has said on many of her shows with regards to supposed mortgage fraud. She is walking such a, tight line with regards to being literally like this guy who just got slammed for 32 charges. Craziness, just crazy why anybody would think that anybody would actually believe this, but obviously there are people that do. Anthony took a lot of people for a lot of money here. Mortgage fraud. Are you paying a company you really owe a dime to? Don't continue to let the alleged mortgage company defraud you and your family of what is rightfully yours. With your current alleged mortgage company, you would pay a 30-year term, and at the end of your payment period, you still wouldn't own your home. This is fraud and deception to the highest level. American homeowners have no idea of the documents that they sign when closing on their homes, and in some cases, is the very reason that some are unfairly foreclosed on. Don't let this happen to you and your family. You have a right to know if there was any fraud involved in your loan process and the servicing of your loan. In most cases, the party foreclosing has no lawful right to do so. There are laws that are in your favor, so don't accept that high mortgage payment. Contact our affiliate law office, Common Law Office of America, and know your rights as a homeowner, and let them assist you in helping us get you a fair deal. Mortgage Enterprise Investment application process is one that is very simple and easy to understand. We differ from other mortgage companies in that we don't put our potential customers through a plethora of forms, red tape, credit checks, and tedious processes. Our application is written in plain language, devoid of the legal jargon that is confusing and hard to understand. Taking steps to save your home. Number 1, application for service. Number 2, QWR. Number 3, affidavits. Number 4, validation of obligation. Number 5, new deed of trust. Number 6, notices. And number 7, continued support. Application for services. The application process includes an agreement for service package. This agreement package is your guarantee that if MEI cannot reduce your monthly payment by half, your initial service fee is returned. A description of what is needed. Number 1, bank, lender, and loan servicer's latest monthly statement. Number 2, a copy of your alleged mortgage/deed of trust. The document recordation number. Number 3, grant deed and the document recordation. Qualified written request. A qualified written request is a written correspondence that you or someone acting on your behalf can send to your mortgage servicer. The purpose of a QWR is to dispute an error related to the servicing of your mortgage loan or to request information about the servicing of your mortgage loan. The MEI QWR is powerful, unlike most have ever seen. The QWR has lawful ramifications for any servicer or lender who answers. It must be in affidavit form, and a notary presentment is used, as well as a responsibility to Common Law Offices of America. You may have previously requested a QWR be answered, but CLOA brings new meaning to holding the alleged mortgagee accountable. I won't read the rest of this because it just gets sillier and sillier, but as you can see, this is all stuff we've seen before. And, validation of obligations and all of these different things sound like really important pieces of documentation. It lends to some form of credibility of his intellect, in his opinion, and many that do not know anything about the financial industry or mortgages may fall victim to this very easily. As a matter of fact, we know several did. He claims that this process puts you in the driver's seat. And as we know from actually researching Anthony Williams and what he did, he actually just replaced your mortgage payment with himself and was collecting those monthly payments with the claim that he would get you out of your foreclosure. And of course, that never happened, not one single time. These are particularly funny. You're going to have the links to all of these to look at for yourself, but the frequently asked questions are priceless. So make sure that you take a look at those. And his paperwork, because they always have packages, right? Look at this. We do have remedy. All right, so these are exhibits that were provided to the court. by the state prosecutor's office on Anthony Williams. And so that is one of the documents that Snoop wanted to make sure that you guys had the opportunity to look at. The link will be in the description for you. Now what we're going to do is we're going to go over and take a look at the actual indictment, because we need to see those 32 counts that he was found guilty on. What you're looking at here is the original document, the original indictment that was actually provided to or submitted to the court on behalf of the state prosecutor's office. And this indictment is on case number 117 CR 00101. This was filed back on March 28th of 2018. You'll be able to see a full copy of it. And as you can see, this is for the District Court of Hawaii. And this was United States of America versus Anthony T. Williams, Annabelle Kabibi, and Barbara Williams. Now, I want you to be aware that the two people that are underneath Anthony Williams' name here, Annabelle Kabibi and Barbara Williams, both of those individuals took a plea deal and in turn testified against Anthony Williams. Okay? This is the superseding indictment. And he was indicted on number 1, wire fraud, 18 U.S.C. 1343. I'm going to go ahead and read through this. And if you choose to, if you would rather read this yourself rather than having me go through it, you are welcome to use the link in the description for this actual PACER document. You will not have to pay for it. This is on another website that is providing this to you. So thank you to that website. Again, it will be in the description. Number 1, Mortgage Enterprise Investments, MEI, as we just heard that MEI being mentioned over and over again in the documentation that was used as exhibits to the court, was a business owned and operated by defendant Anthony T. Williams, which was registered on or about June 24, 2013 with the State of Hawaii Department of Commerce and Consumer Affairs. The application for registration of trade name was filed by Anthony T. Williams on June 1, 2013. The listed officers of MEI were Anthony T. Williams, Chief Executive Officer, Founder, Partner, and Barbara Williams, the Chief Financial Officer, CFO. The application listed the purpose of MEI as a mortgage and foreclosure assistance. Number 2, according to its website, the Common Law Office of America, CLOA, was an office that employs private attorney generals, PAGs, and offers services to its clients that include, but are not limited to, mortgage reduction, foreclosure assistance, UCC filings, document writing, and power of attorney. Anthony T. Williams was the owner and operator of CLOA. Number 3, according to corporate documents filed with the State of Hawaii, the business address for the Honolulu office of CLOA was P.O. Box 31285, Honolulu, Hawaii 96820. According to DCCA's business registration division records, CLOA was not a registered business in the State of Hawaii. Was not a registered business in the State of Hawaii. Number 4, defendant Anthony T. Williams would identify himself as a private attorney general. He carried an identification card identifying himself as a private attorney general from the United States Office of the Private Attorney General, citing 42 U.S.C. 1988. The identification also claimed that the holder had diplomatic immunity and stated, "Do not detain, do not arrest." Number 5, defendant Anthony T. Williams was identified as an attorney in fact on informational materials for CLOA In addition, Anthony T. Williams utilized the email address awilliams@usacommonlaw.com when conducting business on behalf of MEI and CLOA. Anthony T. Williams was not a licensed attorney in the state of Hawaii who was permitted to practice law and provide legal advice to clients. Number 6. Defendant Anthony T. Williams in Hawaii and various other states introduced and advertised MEI and CLOA and the services and products they allegedly provided. Anthony T. Williams would sign up new clients and look for recruiters who, through word of mouth, would bring in additional clients to MEI and CLOA. Number 7. In mid-2013, defendant Annabelle Kabibi was a homeowner and client of MEI who later became a recruiter for MEI. Annabelle Kabibi signed on with the MEI program and later organized meetings and brought new clients to the program. Annabelle notarized documents for MEI and collected a fee for her service. Annabelle would also earn a referral fee from defendant Anthony T. Williams for bringing in new clients to MEI. She also participated in the daily operations of MEI by collecting payments and assisting clients in completing the paperwork necessary to join the program. Defendant Kabibi would allow Anthony T. Williams to utilize a portion of a building owned by her located at 1604 Democrat Street, Honolulu, Hawaii 96819 to conduct MEI/CLOA business and to keep and store business and personal items. Number 8. Barbara Williams was a resident of Killeen, Texas. MEI lists an address of P.O. Box 1215, Killeen, Texas 76540 for the mailing of documents and the submission of payments. Barbara Williams worked for MEI since 2012 from her Killeen, Texas residence and formed a partnership with Anthony T. Williams in 2013. Barbara Williams opened an account at Extraco Bank in Killeen, Texas on behalf of MEI. Barbara Williams would send and receive emails, send and receive mail, make and receive phone calls, maintain MEI paperwork, receive payments, make deposits, cash checks, and make withdrawals. Number 9. MEI and CLOA did business in Hawaii, Texas, Florida, and other states at the direction and under control of Anthony T. Williams and Barbara Williams. Number 10. MEI, Anthony T. Williams, and Barbara Williams, while conducting business in Hawaii, never obtained the required licenses pursuant to Hawaii's revised statutes, Chapter 454, to provide services as a mortgage loan originator company, mortgage servicer, or mortgage servicer loan modification. The scheme to defraud. Number 11. From a precise earlier date unknown, but by in or about May of 2013, and continuing through on or about December 2016, in the District of Hawaii and elsewhere, defendants Anthony T. Williams, Barbara Williams, and Annabelle Kabibi, and others with the intent to defraud, knowingly devise a scheme to defraud and to obtain money from others by means of materially false and fraudulent pretenses, representations, and promises, as well as omissions of material fact, well knowing at the time that such pretenses, representations, and promises were false when made. Such false statements, representations, promises, and omissions of material fact include the following: MEI and CLOA. Number 12. From in or about May of 2013 to and including December of 2016, defendant Anthony T. Williams, on behalf of MEI and CLOA, falsely told potential clients that through MEI and CLOA he could cut their mortgage balances by 1/2, cut their monthly mortgage payments by 1/2, and reduce the current mortgage loan payoff terms by 1/2. In truth and fact, MEI, Anthony T. Williams, and Barbara Williams did not hold the licenses or have the ability to provide a new mortgage, service a pre-existing mortgage, or provide loan modification services to the homeowners. Number 13. Defendants Anthony T. Williams and Barbara Williams, through MEI, provided a 100% money-back guarantee that if they were not able to reduce the homeowner's payment by 1/2 and the current loan payoff term by 1/2, the homeowner would be refunded their initial file setup fee if it was paid in full at the time of initiation of the file. In truth and fact, MEI, Anthony T. Williams, Annabelle Kabibi, and Barbara Williams did not reduce the loan payoff term or the monthly payment because they converted the money paid by the homeowners to their own use, and they did not refund the homeowners money as promised when the original lender would seek to foreclose as a remedy against the homeowner. Number 14. Defendants Anthony T. Williams and Barbara Williams, through MEI, represented to the homeowners that their original mortgage had been discharged or replaced and that a modified or new lower-cost loan was now in place, which was held by MEI. Anthony T. Williams instructed homeowners to make all future payments to MEI, and if their original lender contacted them, to refer the matter to CLOA. In truth and fact, the original lender's mortgage had not been discharged or replaced, and MEI did not have an actual lower cost mortgage in place. All payments made to MEI were converted to use of the defendants and were not used to pay the mortgage on the homeowner's property. Number 15. The homeowners were presented with the MEI Homeowner Service Guarantee Agreement, which placed into writing the 100% money-back guarantee. The HSGA guarantees that MEI will reduce the monthly payment by 1/2 and reduce the current mortgage loan payoff term by 1/2. It also states that the 100% money-back guarantee to me as a homeowner is to ensure that I incur no risk if Mortgage Enterprise Investments, MEI, is unsuccessful in reducing my monthly payment and payoff time. In truth and fact, the HSGA is a false document and no such guarantee can be made, as MEI was not a licensed mortgage company with the ability to create, service, or modify loans, and MEI and the defendants did not pay off the original mortgage. MEI and the defendants merely began collecting half the original mortgage payment and converted the money to their own use, causing the original mortgage to become increasingly delinquent. Number 16. The MEI application, including a Homeowners Guarantee Services Form 330, which promised free or discounted legal services by CLOA. Anthony T. Williams advised clients that if they received any communication from their mortgage lender notifying them of a delinquency of loan payments, to refer their lender to CLOA and their legal representative, Anthony Williams. When this occurred, CLOA would send a letter to the lender and inform them that they are prohibited from contacting CLOA's client and that the lender will be fined $1,000 for every contact moving forward. In truth and fact, Anthony T. Williams was not a licensed attorney in the state of Hawaii and could not represent the homeowner in legal matters. CLOA had no legal right to assess a fine of $1,000 to the original lender. Number 17. Anthony T. Williams would instruct MEI clients to cease all payments to their mortgage lender and begin making all future payments to MEI. CLOA prepared the mortgage paperwork, filed it with the State of Hawaii Bureau of Conveyances, and instructed the BOC to mail the BOC recorded copy to MEI at P.O. Box 1215, Killeen, Texas, as MEI is alleged to be the new mortgage holder. In truth and fact, the original lender still held a valid mortgage on the homeowner's property, which had not been discharged, replaced, or made null and void, and MEI had not created a new mortgage or modified the loan. Number 18. Defendants filed false documents for homeowners entitled UCC Financing Statement and Mortgage, which included a note with the State of Hawaii Bureau of Conveyances indicating that the original loan had been discharged or replaced and made null and void. The alleged mortgagee on the mortgage document is MEI. In truth and fact, MEI had not discharged or replaced the mortgage held by the original lender, provided a new loan, or modified of the terms of the original loan. MEI, Anthony T. Williams, and Barbara Williams were not licensed or permitted to perform those services in the state of Hawaii by the DCCA Division of Financial Institutions. Number 19. MEI would send a letter to the homeowner which thanked them for allowing us to procure your mortgage to reduce your payment and your payoff time. The MEI letter indicated that former mortgage company no longer had an interest in the homeowner's property and that MEI will litigate on your behalf to the full extent of the law. The letter further instructed the homeowner what amount to send as their new monthly payment to MEI at P.O. Box 1215, Killeen, Texas. In truth and fact, MEI did not procure the homeowner's mortgage, and there would be no reduction in payment or payoff time. The original mortgage company still had a security interest in the homeowner's property. Anthony T. Williams could not litigate on the homeowner's behalf because he was not a licensed attorney in the state of Hawaii. MEI and the defendants began collecting half the original mortgage payment and converted the money to their own use, causing the original mortgage to become increasingly delinquent. Number 20. MEI mailed and emailed homeowners false quarterly statements that the defendants produced. The statements contained, among other things, the balance of the purported mortgage and the amount of each monthly payment received by MEI from the homeowner. In truth and fact, MEI did not procure a new mortgage or procure the homeowner's original mortgage and reduce it. Therefore, all numbers provided were false. MEI, Anthony T. Williams, and Barbara Williams are not licensed in the state of Hawaii by the DCCA Division of Financial Institutions to create, service, or modify loans, and MEI and the defendants did not pay off the original mortgage. Number 21. MEI and defendants sent monthly billing statements via mail to the homeowners with payment stubs. Homeowners would send checks for the new payment amount by mail to MEI at P.O. Box 1215, Killeen, Texas. The defendants failed to inform the homeowners that there was no MEI mortgage on their home and that the original lender's mortgage was still valid, thereby causing the original mortgage to become increasingly delinquent. The homeowners. Number 22. In 2013, MV, a homeowner in Hawaii, was told that his mortgage payment would be cut in half if he enrolled in the MEI program. MV paid $900 on or about June 12th of 2013. MV completed the MEI application and other documents, which included the Homeowner's Guarantee Service Form number 330. On or about December 4th of 2013, defendants filed a false UCC financing statement on behalf of MV with the BOC. MV received a letter dated August 28th of 2013 from MEI, thanking him for, quote, allowing us to procure your mortgage to reduce your payment and your payoff time, end quote. MEI indicated that MV's former mortgage company will no longer have an interest in his property and that MEI will litigate on his behalf to the fullest extent of the law. The letter further instructed MV to send his new monthly payment of $886.04 to MEI at P.O. Box 1215, Killeen, Texas. MV sent monthly checks for the new payment amount by mail to MEI at P.O. Box 1215, Killeen, Texas, from on or about September of 2014 and including October 2015. False MEI quarterly statements were produced and sent to MV. In truth and fact, MEI did not procure MV's mortgage, and there would be no reduction in payment or payoff time. The original mortgage company still had a security interest in MV's property. Anthony T. Williams could not litigate on MV's behalf because he was not a licensed attorney in the state of Hawaii. MEI and the defendants began collecting half the original mortgage payment and converted the money to their own use, causing the original mortgage to become increasingly delinquent. Number 23. In May of 2013, ES and AS homeowners in Hawaii were introduced to an associate of Anthony T. Williams who presented the MEI mortgage reduction program to them. ES and AS were told that their mortgage payment would be cut in half and the term of their loan could be reduced from 30 years to 15 years if they enrolled in the MEI program. On or about May 28th of 2013, ES and AS met with Anthony T. Williams, paid him a fee, filled out the MEI application form and documents that were provided to them, which included the HSGA and the HGS Form 330. Annabelle Kabibi collected a fee for notarizing several of the documents associated with the MEI application. ES and AS received a letter dated May 28, 2013 from MEI, thanking them for, quote, allowing us to procure your mortgage to reduce your payment and your payoff time, end quote. MEI indicated that their former mortgage company no longer had an interest in their property and that MEI will litigate on your behalf to the full extent of the law. The letter further instructed ES and AS to send their new monthly payment of $2,095.22 to MEI at P.O. Box 1215, Killeen, Texas. In truth and fact, the HSGA and HGS Form 330 are false documents with no such guarantee that could be made, as MEI Anthony T. Williams and Barbara Williams were not licensed in the state of Hawaii by the DCCA, Division of Financial Institutions, to create, service, or modify loans, and Anthony T. Williams was not a licensed attorney in the state of Hawaii and could not represent the homeowner in legal matters. Number 24. On or about December 4th of 2013, a false UCC financing statement was filed on behalf of ES and AS with the BOC by MEI and the defendants. On or about May 8th of 2015, ES and AS signed a document entitled Mortgage, which was filed on May 26th, 2015 with the BOC. This false document states that it makes null and void the original mortgage instrument recorded in the state of Hawaii, Bureau of Conveyance, and any other instrument preceding it. The document included a, quote, note purporting to set out the terms of the loan and repayment to MEI. The mortgage and the note were notarized by Annabelle Kabibi for a fee. ES and AS mailed monthly checks for the new payment amount to MEI at P.O. Box 1215, Killeen, Texas. The defendants failed to inform ES and AS that there was no MEI mortgage on their home and that the original lender's mortgage was still valid, thereby causing the original mortgage to become increasingly delinquent. Number 25. On or about June 20th of 2013, RL and ML homeowners in Hawaii met with Anthony T. Williams, paid him a fee, and filled out the MEI application and documents that were provided to them. The MEI application and documents offered a mortgage reduction program and were signed by Anthony T. Williams. Annabelle Kabibi collected a fee for notarizing several of the documents associated with the application. The application included the HSGA and the HGS Form number 330. In truth and fact, the HSGA and the HGS Form 330 are false documents, and no such guarantee could be made, as MEI, Anthony T. Williams and Barbara Williams were not licensed in the state of Hawaii by the DCCA, Division of Financial Institutions, to create, service, or modify loans, and Anthony T. Williams was not a licensed attorney in the state of Hawaii and could not represent the homeowner in legal matters. Number 26. On or about October 23rd of 2013, a false UCC financing statement was filed on behalf of RL and ML with the BOC by MEI and the defendants. On or about December 30th of 2014, RL and ML signed a false document entitled mortgage, which was filed on January 6, 2015 with the BOC. This false document states that it makes null and void the original mortgage instrument recorded in the State of Hawaii Bureau of Conveyance and any other instrument preceding it. The document included a note reporting to set out the terms of the loan and repayment to MEI. The mortgage and the note were notarized by Annabelle Kabibi for a fee. RL and ML paid their new monthly mortgage payments to MEI. The defendants failed to inform RL and ML that there was no MEI mortgage on their home and that the original lender's mortgage was still valid, thereby causing the original mortgage to become increasingly delinquent. Number 27. In July of 2013, the MEI Mortgage Reduction Program was presented to LT, a homeowner in Hawaii. LT was told that her mortgage payment would be cut in half, the term would be reduced by half, and the program was 100% refundable. LT signed up for the MEI Mortgage Reduction Program on or about September 29th of 2014. Defendants caused to be produced a false MEI statement which was sent to LT. In truth and fact, MEI and the defendants could not offer a mortgage reduction program in Hawaii as MEI, Anthony T. Williams, and Barbara Williams were not licensed to do so. Number 28. On or about June 19th of 2015, LT signed a false document entitled mortgage, which was filed on June 26, 2015 with the BOC. The document states that it replaces and makes null and void the original mortgage instrument recorded in the State of Hawaii, BOC, and any other instrument preceding it. The document included a note purporting to set out the terms of the loan and repayment. The mortgage and the note were notarized by Annabella Kabibi for a fee. Starting in June of 2015, LT paid 3 monthly MEI mortgage payments directly to Annabelle Kabibi, who would collect them and then send them to Anthony T. Williams. The defendants failed to inform LT that there was no MEI mortgage on her home and that the original lender's mortgage was still valid, thereby causing the original mortgage to become increasingly delinquent. Number 29. In approximately mid-2013, J.A., a homeowner in Hawaii, was told about the MEI Mortgage Reduction Program by defendant Annabelle Kabibi, who encouraged J.A. to attend a meeting. J.A. attended the meeting and heard Anthony T. Williams speak about the MEI program and how it could cut mortgage payments in half and reduce the overall principal. Number 30. Approximately 1 week later, J.A. went to Anthony T. Williams' office on Democrat Street in Honolulu to sign up for the MEI program. J.A. met with Anthony T. Williams and presented her original mortgage to him. J.A. also completed the MEI application packet and provided Anthony T. Williams with a check for $1,000. J.A. was then instructed by Anthony T. Williams to stop payments to her current lender and told she did not have to pay MEI until Anthony T. Williams had drafted up and filed the proper paperwork. On or about June 17th of 2015, J.A. and M.A. signed a false document entitled Mortgage, which was filed on June 25th, 2015 with the BOC. The document states that it replaces and makes null and void the original mortgage instrument recorded in the State of Hawaii, BOC, and any other instrument preceding it. The document included a note purporting to set out the terms of the loan and repayment. The mortgage and the note were notarized by Annabelle Kabibi for a fee. In June or July of 2015, J.A. and M.A. made 2 monthly mortgage payments by check payable to MEI. The defendants failed to inform J.A. and M.A. that there was no MEI mortgage on their home and that the original lender's mortgage was still valid, thereby causing the original mortgage to become increasingly delinquent. Number 31. Defendants did not inform the homeowners that the original mortgages on the homeowners' properties were not paid off and their loans were not modified as promised. The defendants did not inform the homeowners that the payments being made to MEI were being used to pay the defendants' personal expenses and were deposited into MEI's account with First Hawaiian bank account and later an MEI bank account in Texas. Number 32. At all times during this scheme, defendants failed to advise the homeowners that they were not actually creating, servicing, or modifying the mortgages on their homes, and that the document entitled mortgage that was being filed with the BOC was false. The wire communications. Number 33. On or about the dates stated within the District of Hawaii and elsewhere, for the purpose of executing and attempting to execute a aforesaid scheme and artifice to defraud defendants Anthony T. Williams and Annabelle Kabibi and Barbara Williams did knowingly transmit and cause to be transmitted in interstate and foreign commerce by means of wire communications certain signs, signals, and sounds, that is, the following wirings, with each such wire communication constituting a separate count of this indictment. As you can see, all of these specific communications were one count each of wire fraud. All in violation of Title 18, United States Code Section 1343, mail fraud, counts 16 through 32. Number 34. The grand jury realleges and incorporates herein by reference the allegations contained in paragraph 1 through 32 of the introduction and the scheme to defraud sections of this indictment as if fully set forth herein. The mailings. Number 35. On or about the dates stated in the District of Hawaii and elsewhere for the purposes of executing or attempting to execute the above described scheme to defraud defendants Anthony T. Williams, Annabelle Kabibi, and Barbara Williams knowingly caused to be delivered by mail and a private commercial interstate carrier according to the directions therein. The following matter with each constituting and separate count of this indictment. So you can see them here. These are the mailings that they were indicted for and found guilty on with regards to mail fraud. And you can see the remainder in this list. All in violation of Title 18, United States Code Section 1341. And you can see that this was dated March 28th, 2018 in Honolulu, Hawaii, and signed by the Acting Chief, Public Corruption and Fraud Section, and the Assistant U.S. Attorney Ronald G. Johnson. This is the actual indictment, the superseding indictment for Anthony T. Williams. Also, his two conspirators, Annabelle Kabibi and Barbara Williams, who once again took plea deals and testified against Mr. Williams. So this has been a reading of the indictment so that everybody has the opportunity to hear it in case you don't have the time to read it. I know there are many people that were very interested in this particular case, and I wanted for you to know what every single charge was that he was found guilty of. Any additional information that Snoop provides to me, I will bring forth to you as soon as I receive it. As of right now, this is it. I want to inform you that there is another channel by the name of Lone Star 1776, I believe, that likes to talk about how innocent Anthony Williams actually is and how the state and government are after him. I have to say that after reading this indictment and after looking over all of the information that I have in the past with regards to Anthony Williams, including that Snoop for Truth has provided to us, it's very obvious Anthony T. Williams, nothing but a con man. I hope everybody enjoyed this, and I hope you all have a wonderful day. And once again, thanks to Snoop for providing us with this information. Bye-bye.